Okay, I just want to emphasize before I begin that I am not speaking from an ivory tower here in academia, that what I'm going to present is not from an activist perspective. It's going to be a presentation of what the different cases and situations, and so I'm just going to present them to you as I've compiled them, and I encourage all of you, if you have questions at some point or you have comments, to hop right in. But I also, and there'll also be, there's a format in which I'm going to present a quick fact pattern and of a case or a situation, and then the resolution of that particular case will come up afterwards. I mean, we won't have too much time to think about and discuss it because there's I have lots of cases compiled, so I want to give you a good picture of what economic, social, and cultural rights are. But if there's something in particular that you want to focus on, please jump right in and we can discuss it more. But you can also, in that bit before I show you what the resolution of the case is, think about it for yourself, how you think it should have been resolved, or if that was a good resolution. So this entire presentation is going to focus on this single paragraph in the Covenant on Economic, Social, and Cultural Rights, Article 2.1, and I'm going to break it down into specific the phrases in this paragraph. So I'll just read it and you'll get an idea of, boy, what does that mean? Each state party to the present covenant undertakes to take steps individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources, with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means, including particularly the adoption of legislative measures. That seems very convoluted, and it's very difficult, it's very foggy to get into that sector. What is the legal obligation here? And so I'm going to break that down and into the different phrases, and hopefully we'll get an idea of what that legal obligation is. And I don't expect to get through all of the phrases, so especially the last three we definitely won't be able to get to, but they'll be in the PowerPoint and there'll be lots of cases for you to look through that afterwards. So let's just start. And yes, the PowerPoint will be made available to you. So I'm going to go quickly through at the beginning before we get to those specific phrases to talk a little bit about the nature of economic, social, cultural rights. And because it gives a good understanding when we start thinking about what these rights are and what sort of legal obligations they have, to have a contextual understanding. So, and a lot of times I'll refer to economic, social, and cultural rights as either ESCRs or socioeconomic rights, just for brevity, so it's not so much to say. So socioeconomic rights, they started to develop much more, or they really got their traction during the Industrial Revolution, as people became disconnected from land and started to move to cities. And so you had a new social and economic order detached from land, people working in factories, and urbanization. And that's what those charts there show, that as urbanization and moving into the cities and manufacturing work came, that traces the growth of economic, social, and cultural rights as well. So really the beginning of socioeconomic rights are often pointed to in 1941, where the US President Franklin Roosevelt gave something called the Four Freedoms Address, and one of them was the freedom from want. And I emphasize this as well because when we look and see in a moment how economic, social, and cultural rights somehow ended up historically not seeming so important for many years because of the US, it's important to look back to who started this really, and it was the US president. So in 1948, that freedom from want was included in the Universal Declaration of Human Rights. And I put this up because often the Universal Declaration, people might say, oh, well, it's a Western concept of human rights. But if you look there at the countries that were represented on the commission, and then the countries on the left, and then the names there, those were the names of the people who were the sort of the core group. And also Panama and Cuba were two of the only countries that weren't on the commission that they submitted full proposals that were taken into consideration. So that commission, they drew up, including economic, social, and cultural rights into the UDHR. And then that went to the General Assembly, and which at the time had 58 members, and through the third committee, which also has 58 members, to the General Assembly. So it's not just a Western conception of human rights. It is definitely a global perception of human rights. So during the formation of the UDHR, like I mentioned on Monday, it adopted something, the common standard of achievement. And the UDHR was not a legally binding document, as Eleanor Roosevelt, the chairperson, said, that it's something that's more of a moral document. It starts at home. It's individual responsibilities. So every individual and every organ of society has responsibilities as well as rights. Now, just referring back to where this all started with the freedom from want with the US president, understanding how the UDHR, which had both economic, social, cultural rights and civil and political rights, understanding how that split into two is important to look at the domestic situation in the United States at the time. Eleanor Roosevelt, who had been the wife of the president, Franklin Roosevelt, she was the chairperson of the commission, and she understood that there was a small window of opportunity following World War II to get a document. And she didn't want to have, and her staff, they understood that there was a real risk if they created a binding convention that had both economic, social, and cultural rights and civil and political rights. If they tried to have a binding convention, that the United States would not join it. The same as it happened after World War I, where the League of Nations was created and the US ended up not joining it, and it really crippled the League of Nations. So she wanted to make sure it was a document that the US would become part of. And also inside the US, there were two forces that were pushing against human rights. One, this is just an example of a very powerful organization at the time who didn't like this concept of human rights because they said they were preaching equality, she said that the UN was preaching equality to unequal peoples. That goes back to the civil rights movement and not wanting to give minorities in the US equal rights. And then the other aspect was that there was a belief that economic rights were communist rights. So there, the president of the American Bar Association at the time was saying that the UDHR was printed on pink paper. So a lot has been made about the division of these rights. And in 1966, they were divided into two covenants. And there at the bottom, you see basically what a synthesis of why that happened. On the one hand, the Ukrainian member of the Commission on Human Rights said men are free, but are dying of hunger. So they're free with civil and political rights, but they're dying of hunger. They have no economic, social, and cultural rights. And on the other hand, the representative from the United Kingdom said, I can't see that, but the world's needed, I don't have.
Let me address that issue.
The world needed free men, not well-fed slaves. So he was emphasizing that civil and political rights were more important than economic, social, and cultural rights. So we often hear about how these rights were divided into two covenants. And yes, and the claim from those who wanted it divided was that covenant of civil and political rights, that entailed legal obligations. And on the other hand, economic, social, and cultural rights, this was the critique of it, that those were not legal obligations, those were ethics, those were political aspirations, or those were communists, which is seen as bad from the Western perspective. So much to do about the splitting of the rights, But if you look at these pictures here, the dark green countries are the countries that have ratified, that have become state parties, make legally binding each of these covenants. And so anything about the division of these so-called generations of rights, I think is history, because basically the entire world has now rejoined these two generations of rights. And you might notice the light green ones, those are states that are not state parties, but they have signed the treaties. So the United States, they signed the Covenant on Economic, Social, and Cultural Rights in 1977, and which means, according to the Vienna Convention on the Law of Treaties, that if a state has signed it but has not ratified it, that they should not do anything that would defeat the object and purpose of the treaty. So even the United States, which is not a state party, doesn't have the legal obligations of the covenant, is obliged by international law not to defeat the object and purpose of the treaty. So anything about the division of the covenants and anything being that economic, social, and cultural rights are less than civil and political rights, I think is history, and we need to move forward and see what the nature of these legal obligations are.
We do have a question.
Yes,
Do you want
question.
to answer? It's from Stella Mali. I'll just ask them to unmute.
Yeah, there's a question, and so if you could say the question out loud. It was just that one. It was just that one thing there. Was there someone who had a question? Maybe if you just read the question.
Yeah, I can read you the question. So there is a question from Stella Mali. How can we say it's a global conception of human rights when there was no single representation from a whole continent like Africa?
That's a very good point. That's how can we say that this is a global conception of human rights when there was no African representation on the commission, or in the I think there was South Africa, but that's really wasn't representing an African perspective.
Hello.
Hello.
Yes. Okay. So I was having a problem with but yeah, that's just my point. I mean, even if there was a representation from South Africa, it wasn't South Africans. It was, the apartheid government representing, right? So it wasn't technically on behalf of South Africans. So.
Yes, exactly. But what I want to emphasize is at the time, during when the UDHR was created, maybe the world wasn't completely representative. And certainly even the General Assembly, it only had 58 members at the time. So there was lots of the world that did not have representation. But if we look, I'll just have to click in here. If we look at this map again, all of the, not all of, there are, it looks like 3 or 4 countries in Africa that have not become state parties to the Covenant on Economic, Social, and Cultural Rights. But in the time afterwards, all of those countries, or most of those countries, have become state parties to the convention. So what didn't happen in 1948 has subsequently happened since that time. And of course, economic, social, and cultural rights, as we'll get into, are not something that the specifics of how much food, for example, is required for everyone is not the same throughout the whole world. That food has to be adequate, it has to be acceptable, it has to be nutritious to those who consume it. And so there's relativity to the specifics of every single right, even a basic right like the right to food.
Will also wants a question.
Yes.
Hello.
There's another
Hello.
question.
Hello.
Yes. Go ahead.
Okay, so yeah, I mean, I'm reading also the comments during the promulgation of the drafting process in most African countries were under colonization. But I raised that point from like a semantic point of view. So, there was no representation from an African country. So can we, I mean, it's a bit, of course, the provisions are something that can also reflect and that can be also useful for many African countries, despite the representation. But however, still the semantic doesn't really, we can't really say there is a global conception of human rights in during the the drafting process. So that's all.
Yep, thank you very much. And like I said, I would agree that in 1948 we can't say that everyone was represented in their entirety. There are now 191 or 192 state parties to the UN, and only 58 of those were actually present and represented. So semantically, 3/4, 75% of the world did not have any representation at all during the UDHR's actual creation in 1948.
Can you take one more?
Yes,
From Kong?
certainly. There's another question from Kong.
Kong, please.
Hello?
We can just barely hear you.
Maybe you come back in when you have fixed the microphone.
No, I already made my comment. I was just commenting on the question that was raised by our colleagues regarding why there was no equal representation of African countries during the formation of the, during the formation of the economic, social, and cultural right. I was just commenting that perhaps maybe it was because most of the African countries during that time, they were still under colonization, and I guess that might be the reason why, not all of it, but might be the reason, one of the reasons why probably some of the African countries were not represented in the UAGR formation, or during the, or maybe they were not signed to. I guess that's just my opinion. Thank you.
Yes, quite right. The reason that the African countries weren't represented on the Commission for Human Rights or in the General Assembly is that most of those countries at that time were not actual recognized independent countries. They were under colonization. And so they, supposedly, according to the documents at the time, they believed that they had representation through their colonial powers, but certainly we know today that was not real representation through the colonial powers. But I just wanted to emphasize this map again, that while in 1948 there may not have been universal representation, throughout the years afterwards, it has become a universal consensus, or a near universal consensus. There are still a few holes there in the map. So with that map there that has both covenants have near universal recognition, do states have the ability to say, well, civil and political rights are more important and we're going to work on those first, and then we'll get to economic, social, and cultural rights afterwards, once we get stabilized with civil and political rights? Well, the Committee on Economic, Social, and Cultural Rights has said no. It says that similar measures should be taken simultaneously in respect of economic, social, and cultural rights. Oh, I need to go back to the PowerPoint.
Yeah.
You need to click into the PowerPoint. So just another comparison between economic, social, cultural rights and civil and political rights. There's often criticisms of the economic, social, cultural rights, that they're not really law, that the law can't really handle them. There's too high of a threshold, the content is too flexible. This isn't really law. And if we compare that, for example, to the freedom from torture, which many claim is something called jus cogens, that's something that no state is allowed ever to deviate from. And I won't get into looking at the details of all of these, but during the so-called war on terror, the United States actually made the same claims about torture as are made against the right to adequate standard of living, for example, there, or all economic, social, and cultural rights. And so torture, which a fundamental, unquestionable right, some say is use Kogan's, even that was attacked and on the same basis. So the difference between the rights is really illusory. It's not, there's not any real difference. They both are subject to the same criticisms and have the same challenges. I'm not going to spend much time on this except just to point out that the obligations between the two covenants are actually worded quite similarly. I'll come back in a moment to the two blue boxes where there is some distinction between them. And also, I just want to emphasize one more time that the US in 1947 had made a proposal for the UDHR in which they were actually proposing a binding treaty at that time. And the terms from the US proposal from 1947 are actually the ones that have been incorporated into the covenant. So we see maximum available resources, taking steps, appropriate means, progressive achievement, they're all there. So any claim from the US, for example, or from Western countries that these are not really rights, if we look back historically, even those countries have seen them as rights. Another distinction between the two covenants is economic, social, and cultural rights applies to the entire world. There's no territorial or jurisdictional restriction on it like there is on the Covenant on Civil and Political Rights. If we have time, we can get into that more at the end. I have a whole bunch of cases that we could look at that show it, but if not, you could look at the PowerPoint later on. So the nature of the rights. I said we come back to those blue boxes that show the differences between the two covenants. Covenant on economic, social, cultural rights does not have those words respect and ensure. They just have full realization. But the Covenant on Civil and Political Rights also has to give effect to the rights. So if we look at the definitions of these two, what that means is both of them require full realization. And so full realization is respect, protect, and fulfill human rights. And just because the Covenant on Civil and Political Rights also names two of those, respect and protect, or respect and ensure, then that doesn't mean that those don't also exist in the Covenant on Economic, Social, and Cultural Rights. That covenant requires full realization, all three. And just as an example of this, the Committee on Economic, Social, and Cultural Rights in the General Comment 15 has said that there are obligations for direct actions of state parties or other entities insufficiently regulated by states, which is respect and protect. So those are part of the full realization in the Covenant on Economic, Social, and Cultural Rights. And an example of that, this was an older concluding observation by the Committee on Economic, Social, and Cultural Rights. So the Democratic Republic of Congo was called Zaire at the time. And there was a labor code which said in order to work outside of the home or to open an individual bank account, a married woman must present evidence of her husband's explicit consent. And the committee said that this was not appropriate. And if we look at Article 6 on the right to work, we see exactly why. That a person should be able to freely choose their employment. And so that would be a violation by Zaire at the time of the obligation to respect by not enacting laws that are going to enable other people to deprive someone of their right to work. And then just as an example of the other parts of the respect, protect, fulfill, in General Comment 15, the committee has said that it includes the failure to take appropriate steps toward the full realization of the rights. So that would imply more of the fulfill obligation, actually having to take some positive steps. And then I'm mentioning a lot, we'll get into this more tomorrow when we talk about UN mechanisms, but in case you're not familiar with it, I thought I'd just mention who is interpreting when I'm referring to the Committee on Economic, Social, and Cultural Rights. That's the committee attached to the Covenant on Civil and Political Rights. And their mandate includes advising the UN and the agencies, advising states through concluding observations, through cases to those 24 states that have agreed to allow cases, dialogue with states, fact-finding missions, general comments. We'll get into more of the detail of what those are tomorrow when we talk about human rights mechanisms, but I just thought I'd mention it now so that you know when I'm saying the Committee on Economic, Social, and Cultural Rights. That's what I'm talking about. And so the committee, they have a mandate. They're the ones that give the authoritative interpretation of what the covenant means. And that is the representation on the committee as of today through to the end of the year. And just so you get a visual idea of how they work, that upper left picture, that's them working on, that's just the committee alone having some discussion. The upper right and the lower left, that looks like when states are, before the committee does a concluding observation, the states have an opportunity to come in and the committee asks them questions. It's a dialogue that goes back and forth. So those are mostly representatives from the states. And you see in the lower right there, in the back of the room is where the NGOs sit and they follow along as well. So now we're finally getting into that paragraph of the obligations. So the first words, each state party. What does that mean? First of all, it's important to know that when we say each state party, that is the state required to have a certain organization, a certain economic system? And the committee has said very specifically, no, that there are many different systems, there are many economic systems, and all that is required is that the state be democratic and all human rights are respected. So capitalism is consistent with economic, social, and cultural rights. Socialism is consistent with it. There's no particular economic system that is better or worse. You can see there in the second paragraph, it could be socialist or capitalist, mixed or centrally planned, laissez-faire economies. No particular approach is necessary. And when I mentioned that democracy is a required form of government, that is the only requirement that of a state, where it says each state party, that there must be democracy. And we don't have time to get into democracy. That would be a whole nother lecture, a whole nother semester actually on the right to democracy. But I'll just ask this question: is a one-party state democratic? And the committee hasn't really said anything about it, but the literature has said that yes, certainly a one-party state can be democratic. It's not the party, the same as it's not the economic system that's used, it's how the rights are implemented. The same, it's not how the democratic system is formulated, it's the way it's implemented that's important. So a one-party system can be consistent with human rights. So also just trying to define that each state party, what does that mean? Does that mean just the executive branch or the judicial branch, the legislative branch? What does that mean? And so on a situation in Israel, the committee looked at, there was some individuals, a group of people, a minority group who had been moved from one place to another by the state of Israel. And they were attempting to assert their rights. And the executive branch, the president and all of the government departments were saying, well, you have legal mechanisms. You can challenge this in court. So us, the executive branch, are not responsible here. Take it to court. And so the committee has said that no, that actually the executive branch has the primary obligations here, and that one branch cannot simply say, well, the other branches will take care of this. Each state party means the entirety of the state, all branches of government. But what if the government privatizes a sector like water delivery? Does that mean that the government is no longer responsible for the water delivery because the state is not involved? From the same concluding observation, the committee has said that no, if a state cannot divest itself of its obligations under the covenant by privatizing government functions. So the entirety of the government, and they can never give away that obligation. They can't privatize the obligations. They can certainly privatize, but the obligation still exists to follow through as if those privatized organizations were still part of the government. How are we doing for time?
We are now 9 minutes left of the first session, and since we didn't have a break earlier, it would be very good to have it now.
Okay, we'll make sure we give you a break. So each state party again, what about, we had a question about this on Monday, what about social customs? What is the obligation of the state party towards social customs? Well, in a situation in Zambia, the committee said that while noting the persistence of customs and traditions harmful to women, children, and older persons, the state party has within its power the ability to immediately implement the rights of the covenant. In that particular circumstance, they were talking about that the state needed to assert its power to change, one of the situations there was female circumcision, to change that social norm. And if you look in some of the other, I'll adjust this a little bit more because there was a question about it on Monday. If you look at the covenant of the Convention on Elimination of Discrimination Against Women, I think it's Article 2F. It's in Article 2 somewhere, 2F, I think. It says how states are required to change social customs, and the Human Rights Committee attached to the Covenant on Civil and Political Rights has on a number of occasions said specific issues that states are obligated to change. There was a case, Tunin versus Australia, in which it was about gay rights, that states had to implement equality for all. Homeless people, they've addressed a number of times. Yeah, I can't remember specifically anymore, but there's a number of groups that they've said that there has to be, the state is obliged to change certain social customs. And so when we talk about the obligations are on the state, that does not mean that the individual gives up all obligations. That if we look in the UDHR, it says that the state, there's certain rights in circumstances beyond a person's control. So the person has to first try the best that they can, and then the state is there to, as they say, have your back. So that's each state party. Let's move down the Article 2 to take steps. And this is probably the most important part of the obligation, I would say. I'm going to combine all appropriate means into take steps. So when we say take steps, what does that mean? A lot of states have said that, well, that obligation to take steps, that means that we'll get to some obligation at some point. We'll get to fulfilling economic, social, cultural rights at some point. We're going to start thinking about it, and eventually we'll get there. But the committee has been very specific that the obligation begins from day one. So steps must be taken from day one. It doesn't mean that a result has to occur from day one, but the steps have to begin from day one. So don't confuse taking steps with a progressive realization. As the committee said, while the covenant provides for progressive realization, it also imposes on state parties various obligations which are of immediate effect, including take steps. And here are some, this is from the Committee on the Rights of the Child, who have a similar provision, and they have criticized a couple of states, saying that the steps taken were not adequate. Yeah, I put this up so the committee will also look at what the steps are, and will also get involved with issues which you might think, well, this is more something for the Security Council. But and the situation in Guatemala, the committee looked at the peace process. Peace agreement had been signed, and the committee said that the state party is required under that take steps to make every possible effort to provide adequate follow-up. So that taking steps in the Covenant Economic, Social, Culture Rights, that's not only just about what we would normally think of what are economic, social, culture rights, food and housing and water and health. That also applies to peace agreements, because peace agreements, of course, the implementation of peace enables people to fulfill all of those other rights. So when we say take steps, what types of measures are they? And the Convention Against Torture has a little bit of an indication that says effective legislative, administrative, and judicial or other measures. So as we said before, all branches of government, including other measures. So the committee has pointed out a few of these. It says that the committee has said that states should implement economic, social, cultural rights into constitutions, and that they should actually change the laws so that the international rights, economic, social, and cultural rights, but all rights, actually take precedence over any domestic laws. So I've put up there a little example. This is in Norway, in section 92 of the Constitution, has incorporated the human rights treaties into the Constitution. And in the human rights law, section 3, it does say that the provisions of the convention and protocols mentioned here shall take precedence over any legislative provisions that conflict with them. So that's an example of fulfilling these obligations that the committee has mentioned. So we talked about legislative, executive, judicial, the 3 branches of government. And so all of those branches of government are required to take part in these taking steps. And also with the courts, the court doesn't just sit back and decide cases, and this also involves the legislature in changing the court system, the way that the courts operate, or the way that the courts interpret law. So the interpretation aspect may be a development that the courts need to take themselves, or the judges need to take in on themselves to take these steps to implement the rights. So I'll ask the question, should the judiciary interpret domestic constitutions in light of the obligations of the Covenant on Economic, Social, and Cultural Rights? And yes, and so this is the ways that the judiciary needs to actually take those steps with both court practice and in training. So the judiciary can make sure they don't have to wait for statutes to be changed by the legislature. The judiciary can take the necessary steps to make sure that they're trained in human rights.
What did that workshop end up in your presentation?
Yeah, I clicked it up on the website. So these are just some examples of some training seminars about the judiciary that have been done here by the center. The one on the left is Indonesia.
Yeah, it's in Solo.
Yeah, and the one on the right is one that I did actually in 2011 in Vietnam. So taking steps, we're just trying to learn from the practice and the comments by the Committee on Economic, Social, and Cultural Rights, what these taking steps are. We want to try to build more and more of an understanding of what taking steps are from the actual empirical evidence that we have from the committee. So one of the things that taking steps is there must be monitoring of human rights. And collecting of all the statistics and information enables the states to be able to then create good plans. So some of the examples down there, collecting information about homeless people, about those living in illegal settlements, also again, homelessness.
We are out of time.
Okay. We'll pick up, we'll give you a break now. And I guess it's 15-minute break.
15 minutes break.
Yeah. So we'll pick up again in 15 minutes at the top of the hour. So I'll pick up where we left off, that we talked about that taking steps requires monitoring and also establishing benchmarks. But you could ask the question, should benchmarks be universal or should they be individual to each specific country? The committee has said that in its general comment 1, global benchmarks are of limited use, whereas national or more specific benchmarks can provide an extremely valuable indication of progress. So it's national benchmarks that are catered to this particular situation in that country. That is part of taking steps. So things like the Human Development Index, according to the committee, not very useful. So part of those benchmarks is establishing a poverty line. And so is a state required to establish a poverty line? I read that some years ago, Denmark did away with its poverty line and said it wasn't very useful to have a poverty line. But the committee has said that there should be a poverty line, there should be an official poverty line. That's the way to establish what is, what areas need particularly to be worked on. Which brings us then to plans. That's part of taking steps, and probably the most important part of taking steps is creating a plan. So there has to be both national plans, like education plans, economic plans, all kinds of plans, or an overarching national plan. Those are just some examples of some plans there.
You have another question?
Yes, there's another question. Very good.
By Joyce?
By Joyce? Joyce, do you want to pose your question?
Yeah, no, I just wanted to clarify when you said what was that? Sorry. What do you mean when you said HDI is not useful, not being useful?
It's not particularly useful in fulfilling the economic, social, and cultural rights in each individual state. So the committee has said that it's more of the nationally designed benchmarks that are the most important. Yeah, the HDI might give some indication on the performance of states in comparison to one another, but the committee has said that that's not really very useful in a state being able to tackle their economic, social, cultural rights. To know where you rank in relation to other countries is not particularly useful. You need to know what is particularly wrong in that country. Where the HDI can give maybe some indications, it's not really going to be helpful in developing specific plans in that country.
Sorry, is that then, do you mean not having a global indicator?
It doesn't mean that there should not be a global indicator, but just that a global indicator is not the full fulfillment of taking steps.
All right.
So a state that might say, oh, I don't need to create any benchmarks in my country because there's already the HDI, and I can just look to those and I can save all of the effort in them myself and look to those. But the committee would say, no, that the HDI gives you a very general indication of something, and there really has to be to fulfill the taking steps, to fulfill the obligations under the covenant, there really has to be on the national level, nationally created benchmarks.
Can I add to that? Sorry,
yes.
I just can't help it. Because I think there's also an added value to the global ones, because sometimes the national ones are very manipulative. They're very kind of designed not to show the problems, but to hide them. So in that case, it might be good to have something to fall back on, so to say.
Yeah, that can actually provide an indication that the benchmarks are not designed properly when they're showing two completely separate things.
Yeah, because I wanted to ask, because there's the SDG and you have global indicators of all of these things that falls under there, which, yeah. But yes, thank you.
Yeah. So we're talking about plans, that there has to be national plans and also international plans, because in the Covenant on Economic, Social, and Cultural Rights, one of the things that it says is that the steps must be taken through international assistance and cooperation. And so these are some pictures of some examples. The one on the left there, the blue one, is a cooperative plan from Vietnam to receive international assistance from the UN. And the one on the right is a national plan from Norway to provide international assistance. So both of these would be part of the obligation of states to make plans. So the plans have to be both national in implementing the rights within their own country, but also international to get help to implement within their own country, but also to provide help into other countries. So to take steps, what's the relationship to available resources? Is an obligation to make a plan subject to the existence of available resources? Now, the content of the plan may be subject to available resources, but the existence of a plan is not. That's all states are required, even if they do not have enough resources themselves, to hire economists and people to compile the statistics and make the benchmarks. There is always an obligation to do that, and always an obligation to come to a plan. So if a country does not have those resources domestically, the committee has said they have to then get them internationally, either from other countries or from the United Nations. And then the plan, and this could also go to the benchmarks. Is there a substantive requirement? Is it just that, well, I have a plan and therefore I fulfilled the requirement of taking steps? Or if I've made benchmarks, there, I can show some benchmarks. I've completed my obligations under the covenant. But no, there actually has to be, they have to be precise, and they have to be carefully targeted policies. They have to have substance that actually does achieve what they're claiming to achieve. So benchmarks then would have to actually pass some sort of test of whether it be economists or statisticians that might look at it and say, this is just not reflecting the reality of the situation. So then it would not fulfill the obligation to take steps. So the next thing about taking steps and these plans, when do you have to have a plan? At what point does it, obviously you can't have a plan ready on day one of becoming a state party to the covenant. And the committee has said that in that particular circumstance in Benin, that 5 years was not a reasonable plan, a reasonable amount of time. They haven't really articulated how long, and I think it's contingent on what type of plan it is, how complex the plan is, but we have an indication 5 years, probably too long. A reasonable number of years is the test there. So it's contingent on the circumstances. So in making a plan, does the state then have to sufficiently fund what the plan accounts for? And the committee has said yes. And in this particular circumstance, the committee actually looked and said, oh, the state has to increase the budget allocation here for that plan. And so there's been a lot of criticism of economic, social, cultural rights that the committee, or just any criticism of it, is getting into budgetary things, and that's not for human rights to talk about. Committee disagrees that this is something that budgets and allocations, there has to be the proper budget allocations, or a plan is not useful at all. So then you're not fulfilling the obligation to take steps. Yes?
No, go on.
Okay. So what about the comprehensiveness of a plan? If a state maybe says, okay, I just want to take some small steps forward. Well, the committee has said that, yes, maybe small steps forward as part of a larger plan is okay, but the plan has to be comprehensive. The plan has to be looking in the long term as well as the short term. So in this situation in Malta, they said that, yes, there might be a policy there, and there might be part of a short-term plan, but there's no comprehensive national policy for this. And you could look at the Millennium Development Goals that came before the Sustainable Development Goals, and they would not pass this test. The MDGs, the goal was only to halve the proportion of people living in poverty. And as Thomas Polga said, if all goes according to plan, we may then gradually reach an annual poverty death toll of 14 million in 2015, with only 240 million deaths from poverty-related causes during the part of this. Is this a good plan? Is this a plan to be celebrated? The committee would say no, that was not a good plan. It was a start of a good plan, but it was not a comprehensive plan. So we talked already a little bit about the adequate funding of the plan. And the committee has said yes. So if a plan, for example, creates some sort of organization or monitoring body, then that body also has to be adequately funded. So this is all, I just want to reiterate that all of these taking steps, this is part of the legal obligation. This is the legal obligation on economic, social, cultural rights to make these plans toward achieving the comprehensive achievement of human rights. So again, on effectiveness, what we talked about with the benchmarks, that the benchmarks have to be actually effective and effective. So this would be with plans, effective implementation of the plans. So the same with benchmarks, for example, they would have to be effective in their implementation, and so then have effective substance. And then once a plan is in place and is implemented, there also must be effective monitoring of the plan. So in this case, in Honduras, there was a national education plan for all, and lots of countries have these national education plans for all, and something that the UN has been working with lots of countries with. But the committee said when formulating and implementing its national education plan, the state party should also establish an effective monitoring system for the plan. Axel has a question.
Sorry, if I interrupt too much, but yeah. Is the monitoring of economic, social and cultural rights an obligation that kind of stands alone also outside the plan?
Yes, and that's why we covered that when we first started, when we talked about monitoring all of economic, social, cultural rights and creating benchmarks for all of economic, social, cultural rights. But I just wanted to emphasize as well that creating a plan also still requires that monitoring. That monitoring still has to be happening, not just in relation to the situation of the individuals, but also monitoring the implementation of the plan itself. So there's that umbrella obligation to monitor the actual enjoyment of the rights, and then toward improving the enjoyment, you have a plan, and then that plan also has to be monitored. And in the creation of these plans, there is also an obligation of participation. So who should participate in the creation of these plans? The committee says in its general comment 4, all of those affected. So when it's an economic plan for the entire country, certainly there should be a meaningful and effective ability of everyone to participate in the creation of that plan and to give their opinions or to express how it's going to affect them negatively or positively, or what they need to be part of this plan so that they can enjoy their human rights. So on the issue of effective participation, I just wanted to go over a little bit. These 2 next slides are from the Human Rights Committee on the Covenant on Civil and Political Rights. And this affects a lot of economic, social, cultural rights as well, because there can be a development plan. A country may want to do, for example, a mining project, and it's going to affect someone. A lot of times it can affect a minority. And the Human Rights Committee has said that minorities have a particular ability to participate in plans that affect them because it affects their way of life, which is, and especially their connection to land, which is affects their ability to, in cooperation with others, enjoy the minority rights. And this is another case from the Human Rights Committee on a similar situation. And so a state may legitimately take steps to promote its economic development. So that's the economic, social, cultural rights. Yes, you can take those steps, but it recalls that economic development may not undermine the rights. So participation in the decision-making process must be effective, which requires not merely, and this is what the committee says, the Human Rights Committee, which requires not mere consultation, but the free, prior, and informed consent of the members of the community. Now, I would say that this is something that is not entirely decided or entirely, yeah, it's not a settled area of law about whether or not there has to be consent and whether or not there's an ability of a minority group to veto an economic plan. It's a gray area of law. So that's leaving behind the taking steps, what's obligated for taking steps. Now let's look at maximum available resources. So we're going down the different phrases through the covenant. How are we doing for time?
We have
Lots of time left?
yes. 29 minutes.
29 minutes, okay. Not too bad. So when we talk about maximum available resources, what does that mean? Well, the US at the time, in 1952, when the covenant was being drafted, they put forward a proposal, and this is a proposal, the content of this proposal is something that is still, a lot of states still try to use this reasoning. That when it says maximum available resources, it's the available resources that have been dedicated to that particular issue. So if a state budget says 40% of, well, that would actually be quite well, 40% of resources should go to development projects, then the only available resources are those 40%. And if they take the other 60% and spend it on military, well, that's not available resources because the only ones that have been made available is the 40%. But the committee has been very clear that maximum available resources means all available resources, not what's been delegated for development or delegated for rights enjoyment. Maximum available resources is all resources. And so the state will, the committee will actually review budget allocations. Like we talked about that already, but in 1951, the drafting committee, they would say, no, that's not something that the committee should do. It should not get into budget issues. But the concluding observations of the committee in the more modern era would say that the committee the committee actually has got in, and the committee doesn't sit there and demand, you must do this. The committee in their concluding observation always words it as recommendations. So the committee recommends that the state party allocate larger portions of its oil revenue. In that case, or in the Costa Rican case, that it should take effective measures to the maximum of all available resources for social services programs. So the committee will get involved with those budget questions. So it's made comparisons. When it gets involved in those budget questions about budget allocations, it has made comparisons. And so these are indications of how of whether or not the rights have been fulfilled, whether or not maximum available resources have been made available for the enjoyment of the rights. It's not a hard and fast rule, but it's something that gives an indication, and it's the way that the committee has looked at it. So they've made comparisons to both GNP and GDP. And so one member of, this is just a member of the committee, not the entire committee, but he wrote in one of the documents that 5% of GNP on Social Security is not enough. So we don't have a lot of specific indication from the committee on these issues. So I've pulled out what specific indications that there are. And so some comparisons with other expenditures. So for example, 5% of budget on education, where 20% on military expenditure is grounds for a violation, the UNDP has said. So these sorts of comparisons between budget allocations are part of determining whether or not maximum available resources have been made available. But the test that is used, and this is the test that has been adopted into the optional protocol to the Covenant on Economic, Social, and Cultural Rights, is a reasonableness test. Whether or not the allocation of resources are reasonable in those circumstances. So more comparisons on international guidelines. In this situation in Suriname, the state allocates 20% of its national budget to international cooperation resources on children's programs as part of the UN 2020 initiative. But yet there remain widespread deprivations of children's rights. And the committee has said that while the committee recognizes the state party's compliance with the 2020 initiative, not enough attention has been paid in allocating budgetary resources at both the national and district levels in favor of children to the maximum extent of available resources. But just because the state in this situation fulfilled a program of the UN of 20% allocation, that in this particular case, it just wasn't enough. So fulfilling a UN initiative isn't necessarily fulfilling the entirety of economic, social, cultural rights. So there are circumstances where that goes beyond what a UN initiative, for example, would require. And of course, when we talk about maximum available resources, one of the important concerns is corruption. So not fighting corruption deprives the resources that are available. So not fighting corruption becomes an aspect of economic, social, and cultural rights. So what about in situations where there is economic hardship, like lots of layoffs and people losing their jobs because of a pandemic, for example? Well, the committee says that economic, social, and cultural rights are even more relevant in these circumstances. And this is not the area that austerity, as it's called, that cuts should be made, that the cuts should be made elsewhere in budgets, and that in fact, when there are difficult economic times, this is where economic, social, cultural rights are the most important, and the budgetary allocations should be actually increased rather than decreased. What about debt? There are lots of countries that have a significant amount of national debt, and they have huge amounts of expenditures to pay that debt, even just to maintain that debt. Well, in this situation in Nepal, that was the case. And this was the Committee on the Rights of the Child. And that committee was basically telling Nepal, you should fund economic, social, cultural rights programs, even if you're not paying your debt. So not paying your debt would be the first thing that you should cut. So then achieving progressively, moving on down the phrases in the covenant. What does progressive achievement mean? As a legal obligation, what does it mean? Well, in General Comment 3, the committee explains this. The phrase must be read in the light of the overall objective. Indeed, the raison d'être, terrible French, sorry, of the covenant, which is to establish clear obligations for state parties in respect to the full realization of the rights in question. It thus imposes an obligation to move as expeditiously and effectively as possible toward the goal. So the legal obligation, I have the little steps there, taking steps, and the legal obligation begins from day one of being a state party to move toward the goal of full realization of rights. So it's not a matter of we're going to we're going to take some steps, we're going to eventually get to a legal obligation. No, the legal obligation starts from the very beginning. And then when we say moving toward that full realization of rights, what does that mean? When you're progressively moving towards something, what are you progressively moving toward? Lots of targets or poverty indicators might say, well, we want to pull people out of poverty. But as resources of a state increase, so too does the poverty line. And so too does the objective where human rights are going. What is enjoyment of human rights is something that changes over time as resources of a state increases. So in this situation in Austria, the committee said that yes, Austria may have brought a significant standard of living, but there are particularly those in Austria that are still not enjoying all their rights. And even those that are have a high enjoyment of economic, social, cultural rights, it could be even better. So this reflects sustainable development goal number 1, to end poverty in all its forms everywhere. So that's saying that there are many different forms of poverty, not just extreme poverty, but and it exists everywhere. So every state has some form of poverty and can continually be working progressively toward an even greater enjoyment of human rights. Yes, so just showing some examples of what those thresholds might be. You know, there can be physiological poverty, extreme poverty, but then social inclusion, capabilities poverty. There are other conceptions of even poverty that states need to work toward. And that's what the progressive achievement is, progressively trying to move toward those things. What if a state intentionally has retrogression, regresses back in the enjoyment of rights? They might say, okay, we have a plan, and that plan, it's gonna have some costs to it. People are gonna suffer at first, but in the long run, we're gonna get there. Well, both the statement to the World Conference in 1993 and general comment number 2 says that development cooperation activities do not automatically contribute to the promotion of respect for the rights. Many activities undertaken in the name of development have subsequently been recognized as ill-conceived and even counterproductive in human rights terms. The covenant should be given specific and careful consideration. So the committee here is not saying specifically what should be done, but they're saying that in creating development projects, human rights have to be taken into consideration the whole time. So there really shouldn't be a division in the road. It really should stay as one road. Where exactly, whether or not there can be a little bit of regression for a greater good, the committee is not exactly specific on that point. So, all of this that I've been talking about is an obligation of conduct. We haven't at all talked about we haven't at all talked about that a state has an obligation to actually end poverty or to end extreme circumstances. That there's an obligation of states to do certain things, to take steps, to make sure those steps have available resources, to have steps that are moving toward a progressive achievement of something. So in its general comment 3, the committee has said that each state must decide for itself which means are the most appropriate under the circumstances with respect to each of the rights. But, so then the state has the discretion in what conduct it's going to take, but the ultimate determination as to whether all appropriate measures have been taken remains one for the committee to make. So the committee will always evaluate the state's decision on what conduct it's done to determine if it's fulfilled its obligation of conduct. And this just synthesizes what we've been talking about, that you must have certain measures in place, what I call the existential inquiry. Do the measures exist? Are there plans in place? Are there benchmarks in place? Are monitoring? Are all of that in place? Does it exist? And then the procedural inquiry, are the measures actually implemented in fact? And are they actually measures that are going to, that are properly designed? Are they benchmarks that are more tricking the statistics than trying to reflect what the situation is? That would be part of the procedural inquiry. And then there's the substantive inquiry. Are the measures actually reasonable? Are they actually going to achieve what they're supposed to achieve? Yes, Axel, I see you have something burning you want to say. Go ahead.
Now, you want to put this question in relation to your earlier statement that there's no particular political system that has to be applied. If you see what you say, link that to the policies applied and the results obtained. Can you, what is that problem?
Yeah, I would say, and a good example of this would be, for example, a laissez-faire economic system, where the government is hands off the economy to let the invisible hand of the economy, supply and demand, create economic growth. In that circumstance, a state may be a laissez-faire state, but then the committee would most likely, unless the situation in the state was that everyone had great enjoyment of human rights and there was no hunger or anything, which I doubt that would happen, but what the committee would say was, yes, you can have that laissez-faire system, but then you also have to have the backup system to catch everybody who is not enjoying their rights because of that system. So it would be contingent on the particular state and the particular circumstances and how it would result. But any system, laissez-faire or whatever sort of economic system or democratic system that's created, as long as there are additional measures overlapping that, if necessary, to make sure that all economic, social, and cultural rights are fulfilled. So the committee, I think in one way, the committee's been political in the sense of not wanting to exclude any countries and their economic systems. So they've been very inclusive in saying you don't have to have any particular economic system or any type of system other than democracy, and that human rights are fulfilled. So a state is free to design their systems the way they want, but then there has to be steps taken. And so that would be contingent on the circumstances. Yes, so this obligation of conduct. We've been talking about you need to take steps and all these plans and stuff and taking steps and where those steps are going. That there are certain steps which are obviously dead-end steps, or the metaphor here, steps that just go around in circles or just go off a cliff. And there are usually, through scientific analysis, what those steps are and where those steps will lead, there's a reasonable understanding of where they're going to go. It's not always perfect. There can be an economic plan that thinks, and economists may agree, oh, it's going to achieve what we want to achieve. And in the end, maybe it doesn't. That would not be a violation of the covenant. If there's a feasibility of achieving what you want to achieve, then that would be okay. If the analysis of it is that it's just not feasible, it's not going to work, then that is a violation of the obligation under the covenant and under the obligation of conduct in particular. And so this feasibility aspect of it, this scientific feasibility aspect of it, was developed by Arjun Sengupta, who was the independent expert on extreme poverty. And so he said that within every state, in all circumstances, there's some feasible anti-poverty program. And what he was talking about was technical feasibility. He was an economist himself, so he was looking at, from an economic perspective, can we look at a plan and say, this is where it's going to lead? And most economists will agree on this, and so it's feasible. And so if it's technically feasible, if it's scientifically feasible, then it meets the conditions. Then it's actually going up there to the green check. And if it's not scientifically feasible, then it's actually one of the others. This is just an example of a case from the Inter-American Court of Human Rights that have used this feasibility analysis in determining if a state has fulfilled its obligations. So a state cannot be responsible for all situations. They can't be responsible for all results, what the court is saying there. So the results are not what we look at. All we can look at is take into account the difficulties involved in the planning and adoption of public policies and the operative choices that have to be made in view of the priorities and the resources available. So some of the other terms that have been used: is there a sufficient commitment? Are there best efforts? Is there due diligence? So in the designing of that conduct, in the designing of the plans, in the allocation of the resources, in the determination of where the plans are going, was that a feasible conduct to take? Or was it not feasible conduct to take? Was it reasonable or not reasonable? So we look at the conduct, not the result. Now, having said that, I'll now look at the result. So the obligation under the Covenant on Economic, Social, and Cultural Rights is an obligation of conduct, that the states have to have the right conduct. But there is a minimum result. And this is only a minimum result. So the committee has said that there is a minimum core, as it's called, the minimum core obligation to ensure the satisfaction of, at the very least, minimum essential levels of each of the rights. And there's some examples again of how they talk about minimum rights of survival, minimum essential rights, immediate nutritional rights, minimum subsistence rights. So we think about that minimum, that is like the basic needs to survive. That is an obligation of result. So if a state has great policies and their conduct is very good, but there are people who are actually dying of starvation in the country, there is still an obligation, there's still a violation of the covenant for the obligation of result. So there's a little bit of gray area in law here as well about, is this simply strict liability? If there's starvation, then there is a violation. The Committee on Economic, Social, and Cultural Rights has pretty consistently said yes. So the fact of, yes, in this statement to the World Conference, they were talking about 1/5 of the world's population afflicted by poverty, hunger, disease, illiteracy, insecurity. This fact alone is sufficient grounds for concluding that the economic, social, and cultural rights are being denied on a massive scale. So this minimum core obligation, what the committee has said, it's basically a non-fault issue. We don't look at whether the state is at fault, whether the state has done something bad. If the condition exists, then there's a violation of the rights, then the rights have not been fulfilled. So I've tried to graph this as a graphic projection to see, to synthesize all of the rights in all of the aspects of that, what we've looked at of the rights of economic, social, and cultural rights, the available resources, the progressive realization, and the taking steps. And so I've also put on a line there all of the different aspects of poverty, the major aspects of poverty. So starting with physiological survival, people who are dying because of poverty. At some point, you're physiologically efficient. You're not necessarily dying, you're getting just enough, but not much more. And then at some point you meet the moral level of what is seen as like a moral minimum, that anyone living below a certain level is living in very bad conditions. To social inclusion, to capability. I can't go too much into capability right now for time, but the obligation is to take steps. That obligation is to take the steps toward the very top there. So states that might have lots of resources, you see on the left, as their resources increase, then what they're progressively working toward also increases. But, and so if a state has lots of resources, but the realization is very low, then we can say that this is probably a violation of the covenant. And if the minimum core there with the dotted line, if people are dying within the country because of lack of food or whatever, then that's a immediate failure, an immediate violation. Yes.
But it looks here as if the minimum core kind of equals the obligation of result, but the obligation of result also goes beyond the minimum core as part of the progressive realization.
No, the obligation of result is only the minimum core. So once you get outside of the minimum core, once there are no more people dying in a country, then there is no more obligation of result. Then it all becomes an obligation of conduct. So it's all because it's an obligation of conduct because the committee and the interpretation of the covenant looks and says, well, there are so many things that affect an economy. There are so many things that affect economic, social, and cultural rights that there are going to be situations where you did the right thing, but the results just didn't pan out. You did what you thought was the right thing and what science may have said was the right thing, but the results didn't pan out.
But then you have an obligation to review the policies and adjust your policies.
Yes, which is all conduct. So you have the right plan in place, or what you think and hope is the right plan, according to science and according to all of the information that you've gathered. And you implement that plan effectively and properly funded, all conduct to get the plan implemented. The result may not pan out. And so when the result does not pan out, then if you look back at all the steps that were taken, if those steps were reasonable steps, then there is no violation. And this is the main difference between civil and political rights, perhaps, and economic, social, and cultural rights. And it's why a lot of people look at economic, social, cultural rights and say, oh, those are not really rights, and this is not really law. But it's important to understand that it is law. These are legal obligations of conduct to do certain things, to have in place these particular scientifically defensible plans. Oh yes, how much time do we have left now?
3 full minutes.
3 minutes, I don't know. Well, I wanted to just touch on COVID-19, so I can only briefly mention it then, just to sort of synthesize what we've talked about into a particular case. So in COVID-19, if we think about, I just name out a few of the rights. Everyone has a right to these things. And then along comes a virus, and it's affecting health, it's affecting life to some people. Also, education is implied there because people need to have the right information on how to stay healthy. And then we also come into some civil and political rights, privacy and expression rights, freedom of movement rights. So we have these 2 rights. And then we talked about retrogression at one point, going backwards. And so if we look at this situation in the committee from Jamaica, that it was observed that there was some declining quality of education. And so the committee said, if we apply General Comment 3, that any deliberately retrogressive measures would need to be fully justified by reference to the totality of the rights provided for in the covenant and in the context of the full use of the maximum available resources. So perhaps this virus may actually cause some retrogression and actually some deliberate retrogression. As people are quarantined, it hurts the economy, which causes people to lose jobs, which dominoes, and people have less money and they might be more hungry. They might, all of the rights are affected. So there might actually be retrogression there. And so states would be required to explain to the committee why there is retrogression. And there's no real answer to this at this point, but this is something to think about. Studies show, and this is a study from the EU and a study from the US. The US study shows that with every increase of 1% in the unemployment rate, there'll be 47,000 deaths. That's over the long term. Those are people that would be structural unemployment, where the economy has structurally changed so that the jobs simply are not coming back. That may not be the case here. The jobs may come back, but then the overall economy may be hit so hard that the jobs do not come back. And when the jobs do not come back, I think it's like 60% from heart disease, 30% from stroke, 2% from suicide, from the US study. And so over a 10 or 15 year period after the unemployment, 47,000 deaths per 1%. And in the EU, they didn't have any specific numbers, but there is a link between mortality and unemployment. So if we see those numbers on the one hand, and the number of deaths on the other, how is that to be balanced? What is reasonable? I don't have an answer for that today. We don't have time, and I could offer some opinions, but we don't have any case or legal sources to look to help us answer that, other than the general guidance that I've just presented to you. And I would just compare that to the war on terror. And in the war on terror, the US alone spent $6.4 trillion, and the war on terror has resulted in over 800,000 deaths. And if we compare that to what that could have bought in the United States, and down there on the graph on the number of terrorism deaths that have occurred throughout the world, that was probably a waste of money. And so from an economic, social, cultural rights perspective, what could have been the better spending of the money? If all resources go to protecting one right and say, okay, that right needs to be protected 100% or 99%, how does that affect all of the other rights? And so we can look at this and say, if we put all the resources into health, how is that going to affect the other rights? Now, of course, I don't want to trivialize the virus situation and the number of deaths. It's just something that we need to think about in the long term, and how these rights have to be balanced. And I think we're probably out of time now. So the rest of it, international assistance and cooperation, there's also something about most vulnerable groups, and there's one other section that are in here, and there's lots of cases to help develop what that means. And you can look through that when you get the PowerPoint. It'll be put into the Dropbox. So thank you very much for today. And I'll remain here during the break if you want to ask any questions, but do get a break if you need it.